So July 14, 2017 is when the crash happened. And this is an actual video from a bystander.
The 18-wheeler, you see it. Look at the 18-wheeler, Trista. The whole front end's gone. Oh my. With another 18-wheeler, it looks like it's what's in the ditch on fire. Oh my gosh. Oh my. Look at the debris all over the street.
This is awful.
It's
People
terrible.
hurt, bent over. Oh, look at the people laying in the street that were hurt, that were laying in the ditch.
So we represented the members of a band called the Adrenaline Mob, and they were a touring band. Jay has all their albums. They were kind of like a speed metal band, but really fascinating thing. They were a super group, and there was members of the Trans-Siberian Orchestra that were in this group. Really, really talented musicians. And they had played a show in Gainesville, and they were on their way to the next show. And the RV that they were driving in got a flat tire. And they had pulled off the road, and then they had a equipment van that was in front of them. Tractor trailer driver, falls asleep and goes off the roadway, rips through the RV, and it explodes. And this is literally what was left of the RV on the side of the road. I mean, when I say like it burned to the ground, it burned to the ground. This was it. And when we got down there, we were boots on the ground within a day of the crash, and you could still smell flesh burning. Like that smell, I'll never forget it. It was first time that I had ever experienced anything like that, and it sticks with you. I mean, they had all this stuff in a huge dumpster, and it was really, really eerie. This was what was left of the RV, and you see that was the driver's seat.
Jesus.
And yeah, it was terrible. So there were 9 people. 2 people died, and the rest, the other 7 were injured to varying degrees. But this was one of the individuals that died. Her name was Janet Rains. And so Janet, her mom, she wasn't married. Her mom was Lucille Joyner, who was our client. Lucille was 91 years old when the case began. And, the other person that died was an individual by the name of Dave Zabludowski. He was the bassist. Janet was a musician in her own right, but for this particular band, she was being the tour manager. That's just some photographs of her. She had done USO stuff, and really just an amazing human being. And this red hair was kind of her trademark. She went by the name of Jane Train, and really just a beautiful human being. This is her mom, and I set this up just to kind of give you guys a little bit of context of who these folks were before we kind of jump into the meat of all this. And this is what Janet, after the crash, she lived for about 5 weeks in a burn unit in Gainesville, Florida, and then ultimately they had to cut that beautiful red hair off in order to do transplants. This is about a minute clip, and this is why we fight so hard for our clients, because this was Janet's mom, and this was her deposition, and this was her talking about what happened to her daughter when she was in that burn unit. And it's about a minute, and I think it really gives you a good flavor of what this family went through.
Have you, as the personal representative, had to pay any money for her health care bills at Shands?
No, but I saw one of the bills, and it was like $1 million. So it was over $1 million. It was really big, and I said, "Wow, what are they doing?" And then it was a terrible experience dealing with Shands, because they kept telling me, they kept wanting my permission for everything they did, and everything they did was one horrible thing after another. Especially when they, first of all, the nurse told me that they had to vacuum. I think they vacuumed out her lungs, and that she probably would never sing again. That was awful. And then he told me that, well, I think we might have to amputate her fingers. I said, you can't do that. She plays keyboards. And so I don't know whether they did or didn't. And then and the last thing was that they, they needed more skin, so they had to shave her hair, and her hair was her trademark. And I said, so what was left of Janet? They took her her vocal cords, they took her fingers, and then they took her hair. What was left? I just couldn't. To hear all that at the time was terrible.
So,
Oh, that's
you know, knowing
that's heartbreaking, Ed.
that, and I mean that was, you know, that was the reason that you know, we fought like hell for you know, for Janet and for her mom and for you know, the other members of this band, because it really was just absolutely horrific. So here was, and this is going to be the what we did for the summary judgment, and I'll show you the bill of lading and why, you know, how Disney was involved in this case. But, you know, essentially the question became, we had three causes of action against Disney: that they were the real motor carrier, or they were negligent in their selection of the carrier, or there was a joint venture. And the joint venture, very candidly, was the shittiest part. Oh, can I didn't mean
Yeah,
to
you
curse.
can. Dan didn't care.
Okay.
Oh yeah, it's fine.
Yeah, that was the shittiest part of our case, but we needed it in the case, you know, for other reasons, for some discovery purposes.
Real quick before you get into that, will one of the slides give them, or if not, can we maybe give the audience some of the background of the truck company itself and what made you look beyond them and why? Because sometimes you and I, when we talk about this stuff, we jump to the hidden motor carrier stuff, but maybe give them the backdrop of how most cases come to their office and why you knew there had to be more.
Yeah, and that's exactly what I was gonna do now. So
Perfect.
so basically, the company that owned the truck was a company called TWISS Transportation. They had $1 million of coverage. You had 2 deaths, 7 injuries. They vomited the $1 million, you know, within 5 days. And obviously that was, they were woefully underinsured. And so at that particular point in time, you know, we had to say, well, what the hell are we going to do? You know, $1 million is not enough for these families. It doesn't even scratch the surface. So then we had to start digging and looking for who else was involved in the transportation cycle. And I say that transportation cycle, it becomes really critical, as you'll see later, because when you break down the transportation cycle, you'll see that there are other entities that are involved. And in this particular case, that entity was Disney. I mean, literally Disney. And we'll look at the bill of lading in a moment, and I'll explain to you, you know, what that is. But basically, you know, our job was to hold Disney as either the hidden motor carrier in this case, meaning they had control over this whole transportation cycle, or they were negligent in their selection of TWISS. And Jay, remind me later to explain to them some of the work that we did with John Campbell and Phil Miller on the control and the negligent selection stuff.
And that's a good thing to talk about. We'll cover it later, but you know, typically when we do the programs about verdict, we usually do a case overview and what happened in discovery, and then before we get to jury selection, we talk about, okay, did you have a trial consultant? Did you do any focus groups? So I'll make a note to make sure we cover it, because I think that everyone likes to hear about how you did focus groups and what you learned and how it shaped what you did in the case.
It was critically important. When we got down to getting the case settled, it was critically important.
Perfect.
So one of the things that I want to tell everybody, you know, when Dan talked about it really is this is a kind of an art as well. And I try a shit ton of cases. As Jay know, I just came in second, unfortunately, in a case, a couple of weeks ago, but we're in trial a lot. But one of the things that we have started doing, especially in these cases that involve hidden motor carriers or negligent selection, and I cannot emphasize this enough to everybody. file a summary judgment motion yourself. Because what we did, and it really put the Disney folks on their heels, we filed a summary judgment motion saying that Disney was, in fact, the motor carrier and was in control of this transportation cycle. And so what that did is that then allowed us, instead of responding to their summary judgment motion and going second, we then were able to go first, and we were able to frame the narrative for the judge. So what you're seeing here is this is the first thing that the judge heard, not all the nonsense from Disney. He saw our stuff first. We were first to file. And then that means that we got to argue this first, and we got to sequence it and frame it as exactly how we wanted. And the really amazing thing, we did this over Zoom because it was still, the judge was still a little worried about COVID. We had this whole PowerPoint and shared my screen, did the whole thing. You would think that Disney with Pixar at their disposal, they would have, they'd have the craziest stuff. They had nothing, no PowerPoint, nothing, zero. So this was the first question. And one of the things that, the other thing that I would really encourage everybody is when you are doing these, because these cases really, these shipper broker cases, these hidden motor carrier cases, this is the case. As Jay will tell you, like, if you get over summary judgment, they're not trying these cases because I mean they're so bad that potentially, they take a step back and you're like, holy crap. So when we filed this, I'll never forget, and Joe Camerlingo was one of my co-counsels in the case. He's down in Florida, great guy. He's gonna be out in Vegas as well. But I'll never forget the Disney lawyer called up and he's like, man, you guys are out of your minds. Like, there's never been a case in Florida that's held a shipper responsible for the actions of a carrier, because they were saying like Disney was, Disney in this role was kind of this, the shipper. And you guys are going nowhere, but whatever, we'll entertain you. So we're dumb enough to forge ahead, and we do that. And during discovery, you'll see a lot of the discovery as we walk through this presentation. But that's what we kept hearing, and until obviously this summary judgment got denied. And what you're going to see here today is there were the three causes of action. The way that what the judge did is he broke them down, the summary judgments. The first was our summary judgment on the control issue. The second was the summary judgment on the negligent selection. The third was the joint venture. After this, and essentially what our goal was, we wanted our summary judgment motion to get denied, because if our summary judgment motion gets denied, we're moving, we're going to a jury. And so we filed then the defense filed theirs. And so then ultimately this settles, and I'll tell you this gets denied. And then ultimately the case settles after some crazy facts. I don't even know if you know them yet.
I don't think I do.
It was one of the wildest experiences.
I got a call during mediation. I had a call during mediation about one issue.
Yeah. So it was wild. So one of the things that we do now in all of our cases is start off with the judges, a simple rhetorical question, like, why should Disney be held responsible for their role in this devastating crash? And now we're already pumping in there that they have a role. Now, what is that? What is that role? We're already priming the judge that Disney has a role in this. What is it? And so the company, was TWISS Transportation, and that we're now, the next thing we're going to do is show them like the documents and the testimony. This isn't bullshit. There's no speculation. We're not guessing. Like, it was Disney's documents, Disney's testimony clearly and unequivocally showed that it had control over this company, TWISS Transportation. And then this was just kind of an overview. These were literally all the documents that we, uncovered during discovery that established the elements of control in this case. And then these are the folks that you'll hear from today. So starts off and again, you got to educate your judge, because remember in Florida, like all we kept hearing is never been a case, holding, holding a shipper, liable in this particular fashion. So the way that Disney would move its product, this product was coming from Georgia and it was cooking oil. And so what Disney was doing, because Disney wants to be able to maximize profit at the end of the day, that's exactly what they're trying to do. So Disney would take the cooking oil from a facility in Georgia, it was Cargill. And then ultimately, as you'll see on the next slide, Disney was the carrier as well, right? And then Disney was the receiver. So Disney's goal was to move product as quickly as they can from various locations to the Magic Kingdom so that their shelves were always full, their restaurants were always stocked. They could sell as many goddamn turkey legs as they, as they needed. And so this was, Disney, they were a sophisticated player. And it's amazing, as you see, they are a carrier in their own right. And you see down here, they have a lot of power units and a lot of mileage. And a lot of this is stuff that goes on in the Magic Kingdom. But the other aspect of it is them moving their own product as well. So one of the things that we were able to show the judge immediately through this was, hey, we're not dealing with some little mom and pop business. Like, they are a sophisticated player. They're one of the biggest players in the transportation industry in the Southeast corridor. They know exactly what they're doing, and they've set this up in a particular fashion. So these were the people that moves Disney's product. Ben Parker, Senior Manager of Logistics, Brian Wright, Chaz Nardoni, Mike Oliver. And by the way, we did all these depositions over Zoom during COVID. So here was just the basic law of agency in Florida. The existence of the agency relationship is a trier fact. And all we kept hearing over and over and over again, nope, they're an independent contractor. Nope, they're an independent contractor. And so there was some good law in Florida, this Domino's Pizza case. And basically what the Domino's Pizza case said was, look, it doesn't really matter what the parties call themselves. It's what they do. It's how they behave. And so that's where we then started to really peel back the layer of the onion. How did these parties behave in this particular transportation cycle? And so again, good law. It was the party's actual practice, not how they labeled themselves. So this was the first document in the case. And this document started this particular load. And so we wanted to show the judge, look, from the very beginning, it's ordered by Disney. It's delivered to Disney. It's invoiced to Disney. It's shipped via carrier. So that was the question mark. Who's the carrier?
Is this their bill of lading, Ed?
This is not their bill of lading. This was their purchase order. And this becomes probably the most critical document in the whole case, because this is the first document when Disney is going to order this cooking oil. How are they going to do it, right?
Let me stop you for a second real quick, if you don't mind. So this is the purchase order. Have you had cases where, because I know you're going to show the actual bill of lading, but have you had cases where you asked for the bill of lading, they said, we don't have anything called that, but here's a purchase order, here's a delivery order, here's a freight forwarding, here's a, they call it something different. And is that still really a bill of lading with a different title? And what's been your experience on that? It's
a great question, Jay. We have a case literally right now. I just took depositions on it.
I have two right now with that.
Yeah. So what I said, and you use, I could, let me tell everybody what the law is. Hang on, I have it right on my iPad here, which is, is it 42-13-901? That's the
map 21.
The map 21. So I'll find it, but basically there's a code section that says for every transportation cycle, every time a product moves from point A to point B, there must be a writing that evidences who everybody is, right? You got to say where's it going from? The shipper. Where's it going to? The receiver, the consignee, and who's moving it. So what we've been able to show is that, okay, fine, you might have a purchase order, you may not have a i.e. bill of lading, but that purchase order can certainly be the writing that evidences the transportation cycle in conformity with the law. So whether they call it a purchase order or freight forward order or a shipping document, whatever they're calling it, if that's what they're saying evidences the movement of the load, fine, because you can utilize that aspect of it.
Is it the 49 USC 14706?
Yes.
I'll put it in the chat for everyone. No, I'll put it in the Q&A. It won't let me.
Yep. No, Jay, I got it. 49 US 14102 subsection B. And
okay,
it talks about,
and what's that say again?
It says, all right. Nope, I'm wrong. That's the right. I'm just looking for, I just had it up. Hang on one second.
I think it's important so people can.
It is. I'm
they can make notes as to where it comes from. Where the bill of lading is required.
Yeah.
I know written agreements are required. Someone just put in the chat Q&A, Robert Curran did. I know written agreements between brokers, motor carriers are required. That's 49 USC 13901C.
Yep.
Bill of lading I had down is 49 USC 14706.
Yes. Yeah, the bill of lading is 14706, and the 13901 talks about the specification of authority. And that becomes really important when you have a bill of lading. So this was the first document that we had in that Disney, they're going to buy this product, right? And they're going to move this product from point A to point B. And so now this is the first document in this transportation cycle that's showing who's ordering it, where is it being delivered. Payment is critically important in these hidden motor carrier cases and the cases involving control. You have got to find out, got to follow the money, because when you follow the money, you'll see it ultimately shows who's really controlling the whole thing. Now, the question there is like ship via carrier. So now the next document is the bill of lading, right? And so as you see on this is the bill of lading. Carrier name. Every bill of lading has a carrier name. This one was a little bit interesting. And it very candidly is one of the first cases that I ever had where it said something similar to this, at customer pickup vendor. And so now we had to start to dig in, because you see there's only two parties that are identified on this. Cargo is the shipper, where it's shipping from, shipping to Disney, billing to Disney, and now the carrier, Disney's the customer. The carrier name is at customer pickup vendor. So now, as we started to, again, fighting like hell for these families, who is the carrier? Who was the customer? Disney was the customer. So Disney, the question then became, was Disney in control of this transportation cycle? And you see down here, the carrier signature that they were, there was nobody named TWISS on this bill of lading. There was the driver, when he signed this, didn't sign it on behalf of TWISS Transportation. He just signed it, which became one of the things that the judge was very critical of, and had some questions on. Like, well, look, if TWISS is the carrier, then why is TWISS not on there?
And this is something, for you all, that if you get these cases, the earlier you get involved and the earlier you can get in touch with either the adjuster for the motor carrier or hopefully have a lawyer involved. I mean, sometimes you have to file suit right away, but listen, sometimes, if it depends on your jurisdiction, if there's a fatality and you can't file till you open an estate, or if it's a minor and you have to have someone appointed guardian, sometimes you have delays, you just can't file right away. We have sometimes those situations. We always do these preservation layers, and Joe Freed and I did that program, talk about all this stuff to preserve, but preservation layers, I've seen them 20 pages. All I really care about pre-suit early, one of the main things I want is the bill of lading.
Bill of lading.
Documents or any lease agreements and any master transportation agreements, but especially the bill of lading. And if you narrow it down to 4 or 5 things, in addition to maybe inspecting the vehicles and stuff, usually you can get that early because there may be other parties that are responsible. So Eddie, go ahead. I just want to add that.
Yeah, no doubt. And I tell you what, so Jay brings up a great point, and anybody that's on this, shoot me an email, because we have an email that we send out. We have a preservation letter as well, but Jay's right. We have an email that we send out. There's 5 documents that we really want. 5. And email me. I'll send you the email.
What we'll do is I'll get from you like a template of it or a PDF version of it, Ed, and then Dan will upload it to the repository for TLU.
Perfect.
So
because
I'll make a note. Preservation email from Ed.
Yeah, it's literally 5. It's 5 documents, and really it could be 4, but there's 5 things that we ask for that are really critical, and the bill of lading is one of the most important. And so now this bill of lading, as we start to get it, as we start to get into the case, it's like, all right, at customer pickup vendor, what the hell does that mean? And our goal was to show that Disney was in control of this transportation cycle, so such that we got over summary judgment, and obviously Disney had a heck of a lot more, more money than $1 million. So I've looked at this law in probably 30 states, because we were doing this analysis. We had to figure out how this right of control, what it comes down to. And I would tell you that in every state that we looked at, it talks about the manner of which the task is to be performed, and that the party either has actual control or the right of control. That right of control becomes really critically important in these, because even if they didn't do it in your specific case, if they had the right to do it, then that establishes control vis-a-vis agency and makes them responsible for the whole thing. Because remember, there's a real, and this is what, when we're talking about before, like the negligent selection and the control, you got to remember something about coverage, right? And how this all breaks down. Like if you're in a state where there's comparative, the comparative fault and comparative negligence or contrib, well, if you establish that they're the hidden motor carrier and they're in control, the agency, they buy the whole thing, right? They're vicariously responsible for the conduct of the driver. But if it's just negligent selection, now you got a really bad actor in a trucking company, and this guy was, fell asleep at the wheel. The trucking company was terrible. I mean, horrific. So you got a really bad actor, and then you got one that, well, maybe they just shouldn't have hired these guys. So then you got to break down the percentage between the two of them, and that equates to money. So this is like why this becomes so important to establish these elements of control to get you over summary judgment.
If you get agency, they buy the whole kit and caboodle.
The whole thing. They buy the whole thing, right? So this is where it becomes really important. And this is where, later on we talked about like John Campbell and Philip Miller, like when it came down to it, why this information that we got from the focus groups became just vitally important. All right. So one of the things that Disney did, and I can tell you in every single solitary case that this issue comes up, they always say, no, we didn't have exclusive control. Well, the word exclusive doesn't appear in anywhere in the law. That's not what the law says. So make sure, and that was just, we wanted to make sure that we had said to the judge, look, they're going to tell you they didn't have exclusive control. We don't disagree with that at all. By the way, that doesn't appear in the law. That's not the, it's not the law.